Hello, and welcome to FFRF's Ask an Atheist. I'm Liz Cavell, and last Friday, former Supreme Court Justice Sandra Day O'Connor died at the age of 93. On today's episode, we're going to talk about her major rulings on the Establishment Clause and her legacy at the court. Joining me to remember Justice O'Connor is our legal director, Rebecca Markert. Hi, Rebecca.
Hi.
And as always, we want to hear your questions. Either put them in the Facebook comments below or email them to askanatheist@ffrf.org. Justice O'Connor was appointed by Reagan in 1981 and expected to be a staunch conservative. And although she did often vote with the conservative majority, she also became known as a moderate swing vote on many of the big hot issues of the day, like affirmative action, abortion, voting rights, and yes, religion.
We're going to discuss Justice O'Connor's opinions on religious liberty, in particular the Establishment Clause. But first, we need to pay tribute to the first woman justice ever appointed to the Supreme Court. As Liz mentioned, she was appointed by President Reagan in 1981 and served for 24 years before retiring in 2006. You may know there have only ever been 6 women justices to serve on the High Court, and all of them have been appointed in my lifetime. I was 5 when she was nominated to the court, and of course don't remember it at all. But my mom made a special point to share on social media last week what a huge moment it was for women. And I think we tend to forget that women on the High Court is still a very, very recent thing.
So in the most recent episode of our podcast, We Dissent, we talked about the Religious Freedom Restoration Act, and we interviewed Professor Marcy Hamilton. Professor Hamilton is a good friend of FFRF, and she's an expert on RFRA, but she also clerked for Justice O'Connor early in her career, and we asked her about the experience of working for the first woman justice on the court. And this is some of what she shared.
Justice O'Connor became kind of my, mother-in-the-law person in my life. She was this extraordinary mix of just down-home common sense with brilliance, and I've never met anybody who knew how to work professionally and talk to anybody in the world more professionally. So it was a gift. There was never a sense that I was clerking for the first female justice. I was clerking for the original Sandra Day O'Connor, and she never wanted it put in those terms, although what was truly amazing about her is that because she was the first female justice, she received invitations from all over the world to address every possible event. And she took a lot of them. I mean, she really was an ambassador for the court, even more so than the men on the court for a number of years. And it was all about public service. So really was lucky to clerk for her.
That was the one big question I really wanted to ask her when we interviewed her, and I'm so glad that we got a chance to discuss it with Marcy.
Yeah, me too. And you can listen to that entire episode with Marcy Hamilton wherever you get your podcasts or online at we-dissent.org. So,
Justice O'Connor was not always consistent in ruling for strict separation between state and church. As we mentioned earlier, she was part of the majority in cases like Marsh versus Chambers, which upheld the practice of legislative prayer by a chaplain in Nebraska, and Lynch versus Donnelly, which allowed the city of Pawtucket, Rhode Island, to display a nativity scene. But her rulings in other First Amendment cases did show that she genuinely believed that Establishment Clause protects all Americans from both government interference without religious practice and from government action that favors religion. One of the most significant state church cases where O'Connor's vote was crucial was the 2005 case McCreary County versus ACLU of Kentucky. This was the case involving a display of the Ten Commandments, which the court did strike down. She noted non-believers in a concurring opinion that the religion clauses protect adherents of all religions, as well as those who believe in no religion at all.
That quote really exemplifies a view of the religion clauses that today's majority, the far right majority on our current Supreme Court, do not agree with. The fact that the religion clauses actually protect the non-religious or non-adherents from government action that favors religion in general, not just protects religionists from the government favoring a particular religion, was not, controversial even 20 and 30 years ago. And Justice O'Connor really staked out that position and that view of the Establishment Clause, that it's a broad protection for all Americans against any type of government promotion of any type of government view on religion in general. She warned about the court taking the narrower view, which was then in the dissent, on state-church separation. And in that same case, McCreary County, her words looking back now were pretty prophetic. She said, this is the graphic from earlier, those who would renegotiate the boundaries between church and state must answer a difficult question. Why would we trade a system that has served us so well for one that has served others so poorly? And Rebecca, that quote reminds me of, or reminded me of, another thing that Marcy Hamilton pointed out on our recent podcast episode about RFRA, was that when RFRA was enacted, its supporters did not understand that by elevating certain religious believers above everyone else, they were undermining one of the great things about American society, which is that we have lived for centuries without a religious civil war. And Marcy Hamilton is pointing out that that's rare among civilizations, and that that's something that's really unique about American democracy. And it's in large part to our separation of church and state. And that undermining that and the chipping away of that is really undermining, that system that has served us so well.
And that quote is definitely one that has been used over social media and everywhere in many, many years since the Roberts Court has really sort of undermined all of what true religious liberty is. But another favorite quote of mine from the McCreary opinion is one that I use often when we're discussing our own work, because often here at FFRF we hear about from people who are upset that we made a complaint in a particular community, saying that, well, only one person asked us to take this down, and the majority of the community really, really likes this. And why should we have to remove this monument or drop this prayer if the rest of us want it? And Justice O'Connor wrote in the McCreary opinion that we do not count heads before enforcing the First Amendment. I really love using that line, especially when we get reporters calling up and they always ask that question. There's only one complainant that you have. Why should the community do anything? And it's really important to reinforce the fact that the Bill of Rights exists to protect the minority.
Right. And Justice O'Connor really understood that with the religion clauses, that, the whole point of the Bill of Rights is to protect the rights of a minority. And so one complainant is enough. It's not an exercise in majority rules when we're talking about our civil rights and our First Amendment rights. O'Connor also brought clarity to how federal courts handle Establishment Clause cases. So she introduced what we called the endorsement test, and it was a way of framing the analysis of Establishment Clause claims. And what she said was endorsement by the government of a particular religion sends a message to non-adherents that they're outsiders, not full members of the political community, and an accompanying message to adherents that they are insiders, favored members of the political community. Disapproval sends the opposite message. The Establishment Clause prohibits government from making adherence to a religion relevant in any way to a person standing in the political community. And that was how she described endorsement and why government endorsement of any religious position is wrong and violates the rights of citizens, because it makes certain people first-class citizens and other people second-class citizens based on religion, which is forbidden by our First Amendment.
Right. So this was the test that was used for decades, and it did provide a straightforward guidance to judges, litigants, and government officials. We often quoted it and cited it in our legal briefs and complaint letters, and in opinions by other judges upholding the Establishment Clause. If a government action signaled endorsement of a particular religious belief or religion over non-religion, it violated the Establishment Clause. This test was built into the Lemon test, which the Roberts Court recently eliminated in the Kennedy versus Bremer decision from a couple of years ago. This effectively undid much of O'Connor's work and, in my mind, restored confusion and injustice that she had helped to eliminate.
Right. She really, it was sad to see them really just cast aside the endorsement framing that she sort of put together, because it really captured and helped judges understand when and why government action violated the Establishment Clause. And this current court, the Roberts Court, is completely hostile to the idea that the Establishment Clause is meant to protect American citizens against that type of incursion and violation by government action. But in her time, O'Connor also stood up to the likes of Justices Rehnquist, Scalia, and Thomas, right? Because the Rehnquist court was not friendly to the non-religious or, to the Establishment Clause in general. Rehnquist himself and then Scalia and Thomas were often in the minority in some of these cases that did uphold this strong state-church separation that O'Connor often bucked her conservative colleagues. And in cases like the Santa Fe case, which was in the year 2000, holding that prayers over the loudspeaker at public school events violated the Establishment Clause. And also in 1987 in the Aguillard case, which held that teaching creationism in public schools was unconstitutional. Sandra Day O'Connor joined the more liberal justices in holding those violations by public schools unconstitutional and really standing up against what her conservative colleagues would have done in those cases.
Yeah, I think it's interesting to note because Justice Gorsuch is the one who wrote the Kennedy opinion, pretty much talking at length about how awful the Lemon test was and its endorsement offshoots and how it created chaos and confusion in the courts and was unreliable and unworkable. But really, I think I said this on We Dissent when we were talking about the Kennedy decision and what it meant for Lemon. The only place that I really found confusion and chaos was at the Supreme Court. The lower courts found the Lemon test and the endorsement test, again, to be very simple. And we didn't always win. We didn't always lose. It was a right. Very, I think, fair way to analyze the Establishment Clause claims that came before the court. And I think Justice O'Connor's legacy with religious liberty really kind of like exemplifies that because she was not always with us. Like I said at the top of the show, she upheld the nativity scene in one case and then struck it down in the other. And she was for legislative prayer, but then, in the school context was not. So, it wasn't like she was a staunch supporter of it, but she was definitely better than our current court.
Right. And I think she genuinely brought like a fair hearing. She genuinely gave a fair hearing to these claims, which were agreed upon by all justices up until recently to be very fact-specific, case-by-case inquiries, because we're talking about what government action amounts to endorsement or violates the principles of the Establishment Clause. And what she really did for this body of law that has been undone by the Roberts Court, what she really did was she distilled the principles embodied in the Establishment Clause into a workable analysis. So the endorsement test, as maligned and, just dismissed as it is by Gorsuch and some of the other conservatives on the court now, really was this workable way to give practice, give a practical import to these really important principles that are embodied in the Establishment Clause. And so it was routinely applied by lower federal courts with relative ease on a case-by-case basis. And the problems with the Lemon test and the endorsement test came from the Supreme Court's, increasing sort of partisan, pro-religion, pro-Christian stance in not wanting to find for these litigants ever, or not wanting to even agree that the Establishment Clause is meant to embody some of these principles. So yeah, it's sad to see some of her legacy being undone in this area, but I think it was important that she stood for those principles even as a conservative justice on the court.
Right. And I just want to get back to memorializing her as the first woman justice ever appointed to the U.S. Supreme Court. She was heralded as, during her tenure on the court, as the most powerful woman in America. Mm-hmm. She was the swing vote on the court, often along with Kennedy. They kind of switched that up every once in a while. But she took on many of these really important cases, not just religious liberty, but also abortion.
Right.
And she really was, I think I read in one article that, the litigants before the court always, called it an audience of one. They were really just writing to O'Connor.
Right. You're trying to persuade the most independent-minded justice on the court of your position, especially when there's a 5-4 split, as there so often was during the time that she was on the court. And so it really meant a lot to know that she was on the court as the first woman appointed, and also that she held so much power because of her independence and her willingness to sort of buck her party and just do what she thought was right in any given case. And again, she wasn't always in our favor, and she made some decisions that were pretty devastating to some of FFRF's cherished principles. But
I did also want to mention that this morning I did pull up the news and I saw an article that came out on her recently, which was, Justice O'Connor wasn't so great. And of course, it's been almost a week now since she died, and of course these things are going to come out. But I have to admit, I have not read the entire article yet, and I'm sure that there are going to be things in that article that I agree with. It was posted on Salon. But I do think that we cannot understate the importance of what she did, especially for women lawyers in this country. I mean, you have many legal commentators over the last week talking about how important it was that she was appointed to this position, and how she really, everybody says they're a trailblazer when they're the first one, but she really did mentor other women on the court that came after her. And as you heard from Marcy Hamilton, she mentored these young women law students who were just out of law school. And I really think that we wouldn't be where we are now, where we have 4 women justices on the Supreme Court, if we didn't have her on the court. And I really think that cannot be understated at all.
Yeah, totally agree. Right, of course, like all people with so much power, their legacy is always complicated, but we did want to memorialize Justice O'Connor as the first woman on the court, and as someone who really shaped a lot of important parts of the state church jurisprudence, the Establishment Clause jurisprudence, a lot of the court's language that we still use to exemplify our understanding of the Establishment Clause came from the words of Justice O'Connor, and how she approached the inquiry, and also how she understood the Establishment Clause, especially as it applied to minority adherents and the non-religious. So, cheers to Sandra Day O'Connor, not a perfect, uncomplicated jurist, but definitely a trailblazer.
Her judicial thinking will be missed, for sure.
Is already missed.
I'm
going to see if we have any questions on this topic, because it could be interesting. This is an interesting one that is probably a little bleak, but let's tackle it. Is it likely that we'll ever see a judge from the right like O'Connor again, or is the party too far entrenched in theocracy? I think what was cool about Justice O'Connor, and what should be more common, given that our Supreme Court judges enjoy lifetime appointments, is that once you're there, you're there. And, she was one, like I think Justice Kennedy and famously Justice Souter, that were conservative appointments that ended up being huge disappointments to their political party because they didn't toe necessarily the party line. But of course, with that job comes tremendous independence because you're appointed to the court for life. And I admire that Justice O'Connor really exercised that independence, and she used her judgment for better or worse, but she brought her independent judgment to every case. And we don't see that anymore. And I think part of that is because the process of judicial appointments has gotten so incredibly high pressure and partisan and political that it's just so unlikely that you'll get a person on the court that views the job or that approaches being a judge with that level of independence.
Certainly, I think in our lifetime, we probably will not. Let's remember that, again, Justice O'Connor was appointed in 1981. This was at the very sort of beginning of the Christian right movement in this country. Really, they were sort of strategizing and making the plan for the next 40 years. And what we're experiencing now is, the end result of that, the end game of that, where, like you said, the court has been so drastically changed that I don't think any of these justices are going to end up like Justice O'Connor because they're so very extreme, and that was all done by design. And so to answer this person's question, I think the only way you'd see that again is if we enacted some serious court reform and added justices to the bench, or had term limits or a code of ethics, or something that had teeth and enforcement. But I think it's going to be really difficult right now to see someone like her because the justices that have been appointed under the Trump administration have been picked particularly because of their extreme Christian nationalism. And I'm very skeptical that they're going to, in the end, be more middle or even a little more progressive. But I guess this is the point where in our show we'd be saying we should be fighting for court reform.
Yeah. And the reason why reforms are so necessary is because it's the only way to undo or to break down what has happened to the Supreme Court appointment process. Like, it has been so captured by the more political branches of government that it is now a completely political branch, and in order to restore that independence, there have to be reforms because otherwise we are too entrenched in it's too high pressure. These appointments come around so infrequently because our judges have lifetime terms and there's only 9 of them, and so the chance to appoint a justice is so rare and the power is so great and consolidated that the appointment process has been completely taken over by the political branches and the partisan, the process of politics. And so that independence is just winnowing or just vanishing. And so it would take that kind of a change. This is kind of a follow-up to that question. All the questions are kind of in this vein, which is, here's one that is a follow-up to that, and you kind of touched on it, Rebecca. What is the main difference between judges like O'Connor and today's court So with O'Connor's history, although not unbroken and somewhat fraught, her history of fighting against theocratic or more theocratic rulings, and today's court that elevates religion so readily. How did we get here? You kind of foreshadowed how we got here, which is through a concerted effort of, a really powerful network of conservative interests and a strategy, really, to pack the federal courts, including the Supreme Court, with ideologues, non-independent judges who will rule reliably in favor of some of these interests. And often there are these moral, religiously moral interests like abortion and, Christian supremacy in all of these other areas like civil rights.
Right. And it's become so politicized, like you said. I was just thinking I should have looked up to see what the vote was on her confirmation in the Senate, because I don't actually know what it was.
That's a great
But I know a decade plus a few years later, when Justice Ginsburg was confirmed, it was like overwhelmingly, like
almost
93-7 or something like that, almost unanimous.
I'm sure O'Connor's was similar.
Very similar, I would imagine as well. And that just doesn't happen now. We've gone through many Supreme Court appointments just as we've been in our careers as lawyers here and working for FFRF. And they're so party line driven that, also like people pulling their names. We've had justices who are just like, I'm done. I'm not going to go through that process.
Yeah.
And that just didn't happen before when Justice O'Connor and even Ruth Bader Ginsburg were appointed.
And again, because the process has been completely taken over by partisan interests, it is not an independent process. And that's really the proof point of that, is that these are always coming down to, the 50th vote. They're never these, advise and consent, with near unanimous approval, and that's how they used to be. And you can see that change in the process, and that's where the court has become broken. Okay, here's one more question. Do you think the culture of the court when O'Connor was sitting made it easier for her to play a role as a swing judge? Do you think that sort of role could be played so that's kind of similar to the first question, by any currently sitting judges, but just on the point of the culture of the court? How do you view that?
I mean, I think it's hard because right now the culture of the court is a supermajority. They have 6 votes for really conservative causes. And back when O'Connor was on the court, when you had these culture war type issues, the vote was definitely 5-4. And when you have a split like that, it's easier to be a swing vote. I think a lot of people saw Roberts sort of ascending to the swing vote when we still had Ginsburg on the court. And I remember some people even thinking that Justice Kavanaugh would be the swing vote at some point too. But once we had Barrett join the court and they have this super majority, I think it's really hard to say that we could have anybody be the swing vote because they have that super majority.
Right.
What are your thoughts?
Yeah, I agree with that. Because power is so consolidated, it's less and less. It's like anything. The courts become more polarized as one party's power, gets more consolidated at that branch of government. So what would be what's the point of somebody being more independent or open to persuasion when you need 2 people to do that, not just one. These opinions are coming down 6-3. Yeah. And so it doesn't take one swing, it takes 2 swings. And instead what happens is the sides or, the different ideologies get more polarized. And that's really bad because we're talking about the Supreme Court. It's supposed to be non-political because it's supposed to be approaching these cases with really open-minded, independent judgment. I mean, yes, we follow case law and stare decisis, and that's supposed to guide the reasoning of these judges. So independence is somewhat constrained in that way. But what we're talking about when we say independence is political independence. They're not supposed to be towing a party line or, enforcing one group's moral order. They're supposed to be bringing independent judicial judgment to individual cases, and that's what's not happening anymore.
Yeah.
And I think the culture of the court, probably just as much in O'Connor's day as today, but it's coming to a head, is this culture of secrecy and, kind of, I don't know, what's the word for like untouchable, like Mount Olympus type, like levels of mystique and power. It's supposed to, there's this idea, because it's supposed to be independent, that it's somehow above the political fray, but of course it's not. And what that sort of expectation has like engendered at the court is this idea that like they should be above accountability, and they should be above any type of checks and balances from the other branches. And of course, that's not what was ever intended by our framers. They are part of the system of government, and they, the fact that the court has gotten so out of step with what the American people want, and that they have consolidated so much power, should be a reason enough for Congress to step in and check their power, as they're able to do under our system of government. But the culture of the court is that they should be left alone and that they are above reproach. And I think that has made the court even more dangerous. As we see, they absolutely refuse to be bound by a code of ethics that's enforceable, or, that gives them accountability to anyone but themselves. And that's the absolute bare minimum of reforms that the court needs to really regain the credibility and trust of the American people.
You're reminding me too, yesterday I watched a webinar on, I can't remember which the organization was or the name of the author, but he was an NYU law professor, and he wrote a book called How the Supreme Court Divided America. And he was talking about a lot of the things that you just brought up, about how the Supreme Court has really elevated itself to be above the other two branches, when really it was meant to be a co-equal branch of the government. And they really have sort of like made themselves above reproach, being the like final arbiters of what law is in America, and how damaging it has been since we've seen that over the last 40 years.
Yeah. I mean, it is true that they are the ones tasked with interpreting the Constitution, but it's not true that they can never be held to checks on their power by other branches of government. I mean, and that's, that's purposeful, right? To prevent any branch of government from consolidating so much power that the people could never do anything about it, no matter what they ever do. I mean, that's not how any branch of government is meant to function. Yeah. And so I think that's a problem with the current culture of the court, and that probably has been building for decades.
Yeah.
Well, that's our last question. Yeah. So I think we'll cut it off there, but we've got some promos here. So that concludes Ask an Atheist for the week, but don't forget that we also have a weekly broadcast TV show, Free Thought Matters. This week we're featuring the second half of a free-thinking piano concert by none other than our co-president, Dan Barker. Here's a preview.
You'll hear a heavenly tune that went to the devil because those jazz bands, they started picking it, they put a lick in it, a crazy kick in it. They've got a couple of old reformers in heaven, making them go to bed at 11. Pack up your sins and go to the devil, and you'll never have to go
can see Free Thought Matters on TV stations all across the U.S. and also on FFRF's Facebook and YouTube channels.
And don't miss Free Thought Radio. This week, Annie Laurie Gaylor and Dan Barker will be interviewing comedian and abortion activist Liz Winstead, who will talk about making activism fun. You can find the show at ffrf.org/radio.
And again, check out the latest episode of our We Dissent podcast, where you can hear me, Rebecca Markert, and American atheist Allison Gill. Again, we interviewed Professor Marcy Hamilton about the origin story of RFRA and how it has led us to the emerging theocracy we're facing. Listen and subscribe to We Dissent wherever you listen to podcasts, or check us out at we-dissent.org.
If you want more information about the Freedom from Religion Foundation, check out our website at ffrf.org. If you're a member already, thank you. If not, please join us. See you next week on FFRF's Ask an Atheist.